The powers that ought not be have attempted to hide from the people the true power that their county grand juries have. The mission of the New Hampshire Grand Jurors Association is to provide grand jurors with the information they need in order to succeed. And succeed at what? Well, investigating government, uncovering corruption, and reversing this disastrous trend we've seen where government is not accountable to the people in any way, shape, or form. Let's review this quick slideshow, and I think you'll understand what I'm talking about. The Grand Juror Notebook, production of the New Hampshire Grand Jurors Association. History, duties, and obligations. You are the people's sword and shield, protecting against unjust prosecutions while simultaneously investigating government to uncover corruption. Thank you for taking on this responsibility. Missing work or the opportunity to spend time with friends, family, or simply yourself for basically free is a poor trade. Yet you have been endowed with an authority greater than that possessed by judges, prosecutors, or politicians. Please use it judiciously. The Sacred Oath. RSA 600:3. Grand jurors, before entering upon their duty, shall take the following oath. You, as grand jurors, do solemnly swear that you will diligently inquire and a true presentment make of all such matters and things as shall be given you in charge. The state's counsel, your fellows and your own, you shall keep secret, and shall present no person for envy, hatred, or malice, neither shall you leave any unpresented for love, fear, favor, affection, or hope of reward. But you shall present things truly as they come to your knowledge, according to the best of your understanding. So help you God. The grand jury wears two hats. The accusatory role is well known, as mentioned in the early 1990s orientation video produced by the New Hampshire Judicial Branch. The grand jury hears accusations brought by the county attorney and decides whether to issue a true bill, which is an indictment. If they do not believe probable cause exists and refuse to indict, it is said to be a no true bill. And the other hat, government investigator. From the Florida Grand Jury Handbook. The grand jury, in addition to the duty of formally indicting those charged with crime, has the further important duty of making investigations on its own initiative, which it will report as a presentment. This duty permits investigation of how public officials are conducting their offices and discharging their public trusts. The grand jury may investigate as to whether public institutions are being properly administered and conducted. It has the power to inspect those institutions and, if necessary, may call before the grand jury those in charge of the operations of public institutions, as well as any other person who has information and can testify concerning them. If the grand jury finds that an unlawful, improper, or corrupt condition exists, it may recommend a remedy. What is a presentment? From the Webster's 1828 Dictionary Online, in a more general sense, presentment comprehends inquisitions of office and indictments. In the United States, a presentment is an official accusation presented to a tribunal by the grand jury in an indictment, or it is the act of offering an indictment. It is also used for the indictment itself. The grand jury are charged to inquire and do presentment make of all crimes, etc. The use of the word is limited to accusations by grand jurors. It happened in New Hampshire. In the late 1600s, the town of Dover was presented by the grand jury for failing to maintain the town stocks. New Jersey, the armpit of the Northeast, even recognizes presentments. A presentment is a formal document presented by you to the public to call to the community's attention your recommendations as to some aspect of public affairs or conditions. The grand jury is an independent investigative body that represents the public and may therefore inquire into matters affecting community morals, health, safety, and general welfare. In this connection, you may inspect and visit public institutions, agencies, buildings, and departments. If you find unsatisfactory conditions that are of such importance that they should be brought to the attention of the public and the officials concerned, you may return a presentment for that purpose. To investigate such matters, you have the same broad, comprehensive, and independent powers previously discussed. In an investigation that may lead to a presentment, you may cause witnesses to appear before you, and again, you are not limited simply to a consideration of matters that are presented to you by the prosecutor. The Grand Inquest in Action. In 1935, a New York City grand jury investigating organized crime rackets began summoning its own witnesses after being hampered by the district attorney. That grand jury demanded the governor appoint a special prosecutor to assist it. They were given Thomas Dewey. Momentum builds. New York's runaway grand jury of March 1935, which was directly responsible for the Dewey prosecution, is an object lesson in public service. To appreciate its achievements, however, we must realize the difficulties that faced it. The story filled the papers. The grand jury's accusations shook the state. Grand jurors' lives were threatened, but they refused to be scared off. The indictments come down. The special grand jury examined over 500 witnesses during the following 4 months. In December 1935, the panel returned 29 indictments and reported that control over racketeering in New York City centered in the hands of a dozen or so major criminals who extorted millions from the city each year. Epstein's predecessor, a second extraordinary grand jury, took up the racket probe in January 1936. It uncovered a $12 million prostitution racket and put Vice Lord Charles Lucky Luciano and his lieutenants on the road to prison. It's not just about indictments. Sometimes it was not necessary to prefer criminal charges against public officials in order to correct abuses. Grand juries often confine themselves to public statements setting forth irregularities and suggesting reforms in less serious cases. It's about fixing a problem. County attorneys subject to political pressure. The effectiveness with which a grand jury was able to investigate well-organized and large-scale corruption was dependent to some extent upon the cooperation of the county prosecutor. He alone could advise the jurors on legal matters and attend their secret sessions. However, prosecutors were often reluctant to have juries embark upon broad inquiries. Sometimes they feared reprisals, and occasionally they themselves were deeply involved in grafting. If the prosecuting attorney sought to stifle an investigation, its success depended largely upon the initiative and ability of the foreman and his fellow jurymen. Although grand inquests possessed ample authority to disregard the county prosecutor and proceed without his advice, it took a courageous and independent-minded panel to do so. What about the federal grand jury? In March 1992, Rockwell International pled guilty to 5 environmental felonies and 5 misdemeanors connected with its Rocky Flats plant, which manufactured plutonium triggers for nuclear bombs. Prosecutors were elated. The $18.5 million fine was the largest environmental crime settlement in history. The grand jury, however, had other ideas. The majority of the grand jurors wanted to indict individual officials of both Rockwell and the Department of Energy, the DOE. But the prosecutor had resisted individual indictments, so the grand jury, against the prosecutor's will, drew up its own indictment and presented it to the judge. Its action has confounded legal scholars. What is the status or even the correct name of this document? This is from Reviewing Federal Grand Jury Presentments. It was in 1994's Yale University School of Law Journal. For all practical purposes, the federal rules of criminal procedure have abolished the grand jury's presentment power. The grand jury secrecy provisions are so strict that a court may seal a presentment. Since the main function of a presentment, now that a comprehensive network of prosecutors exists, is to publicize wrongdoing, such judicial discretion guts the power. Confusion arises because the rules smother the presentment power without doing so explicitly. The rules conflict with traditional federal practice, and because the Supreme Court has offered no guidance, lower courts have floundered in trying to discern or make the law. Resist the propaganda. This is a screenshot from the current New Hampshire Grand Jury Orientation cinematic masterpiece put out by the New Hampshire Judicial Branch. Learn the truth. Resist the lies. We must take back the grand jury from the gatekeepers. Question and answers. How many grand juries operate in New Hampshire? There are 11, 1 in each county except for Hillsborough, which has 2, north and south. Here are the sources used for this production. And then we have an upcoming grand jury meeting again. January 14th, 15th, and 16th, the new grand jury for Merrimack County will be meeting at 8:30 in the morning at 5 Court Street at the old courthouse, and I'll be there on Wednesday, January 14th, to hand out information again to the grand jurors to let them know what their duties and obligations are and the true power they have to issue presentments, which are indictments from the people versus from the politically motivated prosecutor. And I don't think all the prosecutors are necessarily bad, but we have to admit they operate within a political sphere that grand jurors don't. They're only there for 4 months. So they can really start looking into things that other people might have issues with because it would affect their careers further down the line. But they don't have a career in public service. This is their time to shine. And I think we need to let them know that they can do the same things that happen in New York and all these other cities going back in time. I don't want to get into that right now in this video, but it's a very interesting history of how the county grand jury has really, really caused corrupt government entities to fear. And that's what we need to get back to, honestly. Romans 3:23, for all have sinned and come short of the glory of God. I think this is a good reminder that we've all sinned, and this is not some kind of vindictive mission. This is simply to make government work better. And that's why the New Hampshire Grand Jury or Grand Juror Association, whatever you want to call it, I used the wrenches in the gear, because the concept is that we need to make government work better. We need to figure out where the gears are getting jammed up, or where corrupt entities have stolen the gears and the government's not working at all. And it's not that difficult. The grand jurors have the power to do the things that the legislators have not done, which is ask important questions and get people under oath. And if you need more information, nhgrandjury.com. It's a work in progress, but hopefully in time it'll be a very effective resource for grand jurors in New Hampshire and elsewhere to learn their true power and to start holding government accountable. And, well, with that, we're all done. So have a good night.